Good morning, everyone. Good morning, judges, our faculty and staff. I also want to welcome a special group that's been with us this week. It's our Judicial Academy class of 2024. If you're out there, raise your hands. And just to prove how successful our Judicial Academy course is, one of them just learned that she will soon become, on Sunday, effective Sunday, the Honorable Sandra W. Glevenow. So please join me in congratulating her. Stand up. Welcome to the 145th Justice Jackson Lecture at the National Judicial College. I'm Benna Saldana, president of the college. A one-time Supreme Court justice said, quote, "Education should be a lifelong process, the formal period serving as a foundation on which life structure may rest and rise." I'll tell you who said that in just a moment. Judges, your presence here at the college demonstrates that you understand that learning is a lifelong requirement. You want to be the best judges you can be. You want to help make the world a more just place, which is the mission of the National Judicial College. So you've come to the right place. Before I introduce you to our speaker, let me tell you a little bit about the Justice Jackson Lecture Series, which has been a tradition at the NJC almost since the college creation more than 60 years ago. The Justice Jackson Lecture has traditionally been delivered twice each year during general jurisdiction. Recent presentations, including today's, have been made possible with generous support from Thomson Reuters. So Thomson Reuters, thank you. For those of you who are with us in person, you can see a list of some of our past Jackson lecturers on the back of your program cover. The Jackson for whom this lecture series is named was the 82nd Justice of the Supreme Court of the United States, Robert Howard Jackson, who joined the High Court in the mid-20th century. He's also the person whose quote about lifelong learning I read a couple of minutes ago. Justice Jackson was an attorney from a small town in Pennsylvania. He first went to work for the federal government when a friend of his named Franklin Roosevelt invited him to Washington to serve in his administration. FDR appointed Jackson as a Solicitor General in 1938 and made him Attorney General in 1940. He took his seat on the Supreme Court in the fall of 1941, exactly 2 months and 1 day before the Japanese attack on Pearl Harbor. At the end of World War II, President Truman appointed Jackson as America's chief prosecutor in the Nuremberg war crimes trials. Jackson always regarded that as the most important event in his life. As Jackson addressed the Nuremberg court on the first day of the Nazis' war crimes trials, he knew the world was watching. He knew it would be the most important speech he ever made. Never before had the leader of a nation been put on a trial for war crimes. He told the Nuremberg court, quote, "The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated." During World War II, the Supreme Court heard a memorable case, Korematsu versus the United States. that challenged the incarceration of Japanese Americans after the bombing of Pearl Harbor. A young shipyard worker in the Bay Area, Fred Korematsu, had refused to report to the internment camps. He was born in Oakland. In fact, he lived there all his life. He thought it unfair and unconstitutional for him to be, in effect, imprisoned without trial simply because of his race. Justice Jackson called the executive order that established the internment camps an order signed by his friend Roosevelt, quote, the legalization of racism. And he didn't stop there. He compared Roosevelt's incarceration order to, quote, the abhorrent and despicable treatment of minority groups by the dictatorial tyrannies which this nation is now pledged to destroy. He was talking, of course, about the fascist Axis powers in World War II. Jackson unfortunately held the minority view in Korematsu versus the United States. The court voted 6-3 to let the incarceration order stand. Today's Jackson lecturer knows something about being singled out for different treatment because of one's race. A member of the Hopi tribe, she is a national expert on Native American legal issues and has instructed law enforcement and prosecutors on the topic. Earlier this week, she received the 2024 Chief Standing Bear Award for Courage. The award was created by the nonprofit Chief Standing Bear Project to promote the life and civil rights legacy of the famed Ponca chief, who won a court ruling that declared that Native Americans were people under U.S. law. How many people know who Chief Standing Bear is? Who else was? A few? Okay. I was going to do a long recitation about him, but now that we have ChatGPT, you can learn in a few minutes. So I want to take the time to please write that down, Chief Standing Bear. Learn about his story. It's amazing. I myself just learned about him last month when I visited my last 50th state in Omaha, Nebraska. So please do so. 10 years ago, our speaker became the first Native American woman and the first enrolled tribal member to serve as a United States federal judge. She remains a judge of the United States District Court for the District of Arizona. Recent national polling by the American Society of Trial Consultants, American Board of Trial Advocates, or ABOTA, and the Online Courtroom Project found that about 44% of Americans either completely distrust or somewhat distrust our court system. Less than 9% said they trust the courts completely. Our speaker this morning will be sharing her thoughts on how judges can instill confidence in the courts. And there should be time for a question at the end. So please join me in welcoming back to the college an alumna, friend, faculty member, and distinguished jurist, the Honorable Diane Humetewa.
Thank you so much. I'm assuming there will be very few questions because we're right around the lunchtime, right? Everyone's hungry, and I know some of you are heading out. I want to, first of all, say how moved I am to be back here. I have been a faculty here, and it's been quite some time since I've visited the building. President Aldana and the staff have treated me like royalty coming here, and I want to thank them especially for their treatment of me and the invitation here. If you look, I made the mistake of looking at those prior speakers in the Justice Jackson lecture series, and I thought, oh my goodness. And I know one of my colleagues was recently up here speaking to you, and I can only imagine that I'm going to struggle to measure up to her words. But I also want to say that I've had the opportunity to work with the well, your president here, President Aldana, as part of my role on the Judicial Conference's Committee on Federal State Jurisdiction, which also encompasses tribal courts and territorial courts in its work, and that's at the national level. So here today, you have seen the title of my talk. It is Reposing the Public Special Trust and Confidence in Your Wisdom, Uprightness, and Learning, a discussion about instilling and maintaining confidence in our courts. Well, this title is not original. Those who know me well know I'm not that profound. The first part of this title, Reposing the Public's Special Trust and Confidence in Your Wisdom, Uprightness, and Learning, are words that hang on the wall in my judicial chambers. They are contained in the text of the commission I received by President Obama. The commission starts, "To all who shall see these presents, greeting know ye, that reposing special trust and confidence in the wisdom, uprightness, and learning of Diane J. Humetewa of Arizona, I have nominated, and by and with the advice and consent of the Senate, do appoint her United States District Judge for the District of Arizona." These words are indeed in every commission of every federal judge named to the district court bench. And I suspect, like me, that from time to time, each judge revisits that language of their commission to remind them of that proclamation. It's a years-long historic proclamation that is pronounced. So as I considered what to say to you today, I was thinking about the nature of the commission's charge and what it meant, not just to me, but to all who may read it. That in turn made me consider how we as judges and those who wish to be judges can ensure that the public has trust and confidence in our wisdom, uprightness, and training and learning. Well, the terms wisdom and learning are readily understandable. We all have achieved or strive to achieve a level of education, and for the most part, a Juris Doctorate. And we have all achieved some level of experience in the practice of public or private law, so that we are familiar with the courts, their procedures, and practices. But what does the commission mean by uprightness? Uprightness. Well, Black's Law Dictionary says the word is synonymous with integrity. Merriam-Webster says it means one marked by strong moral rectitude. Words like decency, honesty, morality are associated with being upright. How do we as judges repose or assure the public's confidence in our uprightness? We all know that no one comes into these judgeships with a blank slate. We all come with, and from our own religions, cultures, races, genders, sexual orientations, and political leanings. I think many of us learned that maxim long ago, that justice is blind, suggesting that individuals who sit as judges must not see beyond the paper pleadings before them. I've learned that that kind of blindness is impossible and impractical for many of us and for a wide array of reasons. Now, I've been on the bench, as you've heard, since 2014. And since then, my thoughts on the question of how we can instill the public's confidence in us have evolved through my own experiences and observations, and I want to share some of them with you now. Well, first, during my pre-nomination process, a White House staff member told me during our vetting process that if I was nominated and confirmed, that I would be the first Native American female to be confirmed as a federal judge. And he asked me, how would you respond to that? And I have this vivid recollection of this long silent pause. In my mind, I felt like it was 5 minutes. But in my head, I was thinking to myself, it's 2013, how can that be? You know, how could that possibly be? And then I said something to the effect that, well, I would be honored to have that moniker. But then I followed up with, regardless of that distinction, I will work hard to earn the trust of anyone who appears before me. I was trying to message that my decisional process as a judge would not be affected or influenced by the fact that I am an enrolled tribal member, and that I wouldn't be influenced because I was nominated by a Democratic president. These facts about me, however, are publicly known, so it was at this time I began to think about how this would affect the public's views of my decisions. Then in 2014, shortly after taking the bench, I did accept an invitation to give my first public talk to a conference of Native American students at Arizona State University. The talk was meant to encourage the students, a majority of whom were first-generation college students, to think about their futures, to promote education, essentially a platform for me to say, if I can do it, you can do it. I was so excited to be there, and the group was so energetic and happy. But I suddenly became mindful of my new position. I realized that my words would carry beyond the audience. And I suddenly found myself trying to walk a fine line between openly sharing a part of me that would resonate with these students and not sharing too much of my personal self that other parts of the public, which I now serve, could not or would not identify with. My fear was that I did not want this part of the public to question my fitness as a judge on account of my racial, religious, cultural background, which was unquestionably different than most of the public I was to serve. Now, at that time, Arizona was experiencing racial tensions aimed at our growing immigration population, open contempt for religious practices and attire, and there were constant demands for immigrants to immediately assimilate into the community. And in this context, I thought that it may be best to avoid publicizing my personal differences to the general public. So my immediate thought was, I simply asked the organizers, please don't record this discussion. Now, since then, I wondered, is there a tension that comes from a judiciary that reflects the greater society and the local community? Indeed, for years, we have strived for courts that include judges who are representative of the community. We have seen the appointment of more women to the bench and people of different national origins, cultures, and sexual orientations, and we have applauded that diversity, as we should. Yet, when those efforts yield success, I am mindful that some segments of the population may feel disenfranchised, may even feel concerned, because they have a belief, perhaps, that certain judges' backgrounds will preemptively deny them justice. And still, another segment of a population feel empowered by the appointments or nominations of certain judges, believing that a judicial opinion will sway in their favor based on their race, their religion or sexual orientation, or political party of the judge. And the media undoubtedly contributes to these tensions, even though in my case, a federal judge's case, the lifetime appointment is intended to shield Article III judges from the pressure of politics. The media often politicizes our positions by referring to us as, quote, an Obama, a Bush, or a Clinton appointee. And similarly, I think for a lot of judges here, reporters often reference the state governor that appointed you, as if to add in there a hidden message, and that is why he or she ruled the way they did. So indeed, a recent report that President Aldana shared with me, 2024 report on state courts, noted that based on its 2023 survey, more Americans see the court as political, which was a 5-point increase from the prior year. And this sentiment ran across all political spectrums. Finally, a recent experience with a law clerk applicant really brought home the political concern for me. In a round of law clerk interviews, the applicant's parting words to me included that he would feel, quote, honored to work for me because of the president who appointed me. He inferred to me that the president's party's belief closely aligned with his and the community from which he came. In fact, I felt that it was something that he had practiced. And it caused me great concern because this was a law student embarking on a career that included clerking for a neutral. And the kind of politicization of the law seems to be central in the growing distrust in our independent judiciary. So all of this has made me take a moment to reflect. And what I say to you really is not that profound, but it's something that I think bears remembering. I ask myself, what is to be done when we, as members of the judiciary, are losing confidence in the very members that we are supposed to serve? How do we quell the concern of the public that our personal differences will not define how we carry out our solemn responsibilities? How do we respond when our own protégés expect judges to show bias? What is our role? Do we have one? And I believe we do. And I think this is important for those who are aspiring to be judges, because being a neutral is not all that is involved. There's more that you are going to be required to do. I believe we first have to go back to that basic premise that we hold the position not just through education and learned experiences, but we hold them based on our uprightness, our ability to be decent to the parties who come before us, honest in our application of the law to the facts presented, and moral in our conduct, both on and off the bench. Indeed, it is the outward public demonstration of this uprightness that can contribute to the public's perception of what a judge's responsibilities are, and thus how the larger judiciary should function independently. I offer that we can contribute to a change in perception of the courts and of judges in some real and meaningful ways. First, we must be upright in all we do on and off the bench and in and out of the courtroom. In the courtroom, being decent to the individuals who appear before us. Before taking the bench, consider whether the person appearing before you has ever been in a courtroom before. Consider the education level of the individual. Consider, and this is a real bell ringer for me, consider the legalese that we so naturally employ in our daily lives, in our chambers, and with our colleagues, and whether or not this translates well to those appearing before you. In other words, clearly explain the decisions that you're making and why you're making so that the individual, not the lawyer, understands them. In your judicial chambers, being moral and decent to those who work for and with you. This seems common sense, and I think, though, that many times when we take on the role of a judge, we don't think about the role of administrator, manager, and supervisor. We're simply thinking about administering law in our courtrooms. Well, we're not quite out of a time where we educated and learned judges often fail to police ourselves. Indeed, in my own circuit, we lost a former chief judge to early retirement based on allegations of sexual harassment. We thought those days were behind us. But more recently, I'm sure many of you read and learned that a fellow district judge resigned and now faces impeachment for similar conduct. And we are now grappling with the aftermath of that conduct. And that does not just include the aftermath to the staff, but to the court and the very cases, civil and criminal, that judge presided over. Now, while the Administrative Office of U.S. Courts and similarly state court administrators try to implement programs and protocols to prevent and discipline these circumstances, public discipline should not be our goal. The goal should be that we as judges and as managers and as supervisors ensure morality reigns in our judicial chambers. Second, we must be honest in our interpretation of the law. In each opinion you issue, whether you agree or disagree with it. Another recent survey interviewed retired judges, one of whom believed that judges who, quote, legislate from the bench are contributing to these problems of public perception. So we each must approach the law carefully, especially when there is no clear statutory meaning or prior precedent. Sometimes it means explaining to the parties that absence of clear law should be brought to the attention of the legislature, and that you, as a judge, will not be fulfilling that responsibility. Third, we need to let our differences, we need not let our differences distract from the, quote, special trust and confidence in the wisdom, uprightness, and learning of our nominator, that our nominator placed in us, whether that be a governor, the public, the president. Now, this should not mean that you disguise your faith, race, beliefs, or other attributes to the public, as I have come to learn. Because for me, these attributes certainly do play an important role in bringing confidence to the justice system, and importantly, preparing the next generation of lawyers and judges who may not have had such a pathway. It is meaningful to them. But it is important that you demonstrate that these personal attributes, while they may inform you, will not detract you from your decisional processes. Each one of us must come to understand how to do that for ourselves. Lastly, and of utmost importance, I think it bears mentioning and really thinking about it, especially during this time of year, that we each must adhere to the, quote, rule of law. The phrase was first coined in the work of the United Nations, roughly about 10 years ago. It was necessary to come up with the definition to define the countries and states that were, where there was rule by law. In other words, law that those in power are not subject to, and those who adhere to the rule of law, where everyone is accountable to the law regardless of race, sex, or economic standing. For years, the United States was the standard by which those countries adhering to rule by law fought for. It was our independent judiciary that laid the foundation for that standard. Yet today, these core principles seem to be shifting. When we divert from those core principles, though, we divert from the core rule of concept that is so integral to our democratic governance, our entire democratic governance. I know that the goal of improving the public perception of the courts and judges at this time in our respective lives and in our respective communities, and indeed in the nation, it feels like rolling a boulder uphill. And I, like you, will continue to cringe when we read the national data and statistics that talk about our highest courts being underwater in terms of the public's perception of its role and responsibility. But I say to you that each day, you and I have a real opportunity to demonstrate that we are upright, and we are willing to serve in a just and fair and equal way to the individual that appears before you in that moment. And I think in our individual actions, we can turn those perceptions around. Even if we're not striving for a national turnaround, in your local community, in your courtroom, in your cities, in your local bar associations, it will make a difference. And so I do appreciate you letting me indulge you in some of my thoughts. And I do appreciate your time and attention, and I appreciate your willingness to continue your educational process and be reminded of these core values. Thank you for letting me share this time with you. Thank you, President Aldana. I am happy to take any questions or comments or critique. I promise not to lecture on juveniles' motions to dismiss.
Any questions? Ed,
Do we have any mics?
go ahead.
Okay. You talked about the judge's responsibilities and about the court's behavior inside and outside of the courtroom. Do you think it's a responsibility of a judge to go out in public and speak to groups? And how do you feel about judges' participation in social media?
Well, the two questions are, do I think, well, the first one is, do I think that judges should be involved in the public and making public statements and so on?
Not necessarily statements, but going out and speaking to groups, maybe explaining about the role of a judge, responsibilities, that sort of thing.
Oh, most definitely. I think we do also have a responsibility, especially because we have such a interesting time in our lives over the last, I'd say, 10 plus years. We have shifting curriculum in the schools that have backed away from civics education. And I think in my observation, one of the things that happened during my time as a college student, as a law student, we really didn't have curriculum that taught us about the third branch of the government, the courts, right? And what the courts were meant to do. And I think it was with Sandra Day O'Connor's iCivics education that she began launching this awareness of all of the branches of the government, the co-equal branches of government. And I think it's really important for us to continue on with that good work, especially at the local level. And it brings to mind this, and I especially want to speak to those of you who are aspiring to go to the bench. When I was appointed and I came into my position, I didn't realize that there were all these additional extra duties. Our administrative offices essentially use us as volunteer workers and the lawyers in our community to stand up education programs, to reach out to local community high schools, to bring them into kids to court. All of that is essentially extra work that you're doing in addition to your casework. But it's incredibly important. After I thought, how am I going to do all of this? I realized later on that when you're reaching out to those communities that really don't have a lot of access to your courtrooms or to your general judicial community, it really makes a difference. It's important for you because if not you, then who, right? The second question was whether or not judges should be on social media. This is really, for me, I was talking to one of the students here, and I will tell you this, it was so interesting because I came up in a time where I'm not very electronically savvy. In fact, I think it's one of the frustrations of my law clerks. But when I was going through the nomination process, the vetters basically said, we want your Facebook password, we want your Twitter account and all of that. We need to scrub through all of that. And I said to them, I've never set up a Facebook. I maybe set up a LinkedIn, but never used it. And they were flabbergasted. But then they said, thank you, thank you. And my colleagues who were going through that process had a very difficult time. They had to turn over passwords. They had to, tell their children to get off Facebook and stop posting pictures of them. I don't know what they were doing, but to be very honest with you, I think we're in a different day and age where I think if you're properly using social media in a way that is responsible and you're sharing those messages, I think that is important. But I also think be very careful with what you do and post on social media, especially those of you who come from states where you have to run for your position once you're in it. It becomes very dangerous. And so I think if you use it in the right and proper way, I would shy away from it, frankly. But if you use it in a proper way, I don't see any reason why you should not. Yes?
We have a question from the chat, and they're not going to be able to hear me, so if you can repeat it. What role, if any, do cameras in the courtroom have in increasing public confidence in the judiciary?
The question is, what role do cameras in the courtroom play in instilling confidence in the judiciary? I'm going to give you my personal experience and thought, and then I'm going to probably back away from it a little bit. When I first worked as a lawyer in the United States Senate, they were using C-SPAN. In fact, I think this was when I was a extern in the Senate as a second-year law student. By the time I started working as a lawyer in the Senate, they began publicizing on C-SPAN 24/7 what was going on the House and Senate floors. And I believed at that time that watching individual representatives in the House and the Senate, they had a lot of camaraderie, there was a lot of working together, talking to one another. And I thought, my observation was, after going back and looking at now this 24/7 coverage of what's going on the House floor, it changed the dynamic of our congressional body. So I also think that, and I'm dating myself, and maybe a couple of you, very few of you, probably remember the Simpson trial. The first time that you had cameras in the courtroom for the duration of the trial, and really what that did to the public's perception of the lawyers and the judge. People paying too much attention about what they were wearing, how they were presenting themselves, and not on the case. So I do think that there is an effect. But if you are coming into your positions at a time where you're used to having those cameras on, your telephone on, and you're able to conduct your work in a way that you're not distracted by it, more power to you. I just feel that when I see parties that are not distracted, and I have the benefit of that, we in the federal judiciary don't have cameras in our courtroom. It's an ongoing debate. I would rather the lawyers, not to say that they wouldn't, but I think some would, I would not want them paying too much attention of how they appear to the public as opposed to what they're doing in the moment in the case. How many of you have cameras in your courtroom? A few of you. And I think I would defer to them and see whether or not they feel that there is a difference. There's something to be said, though, about the public accessing justice in that way. But I do tend to lean toward not preferring cameras in the courtroom. Anyone else?
We have one more, time for one more question.
Oh, yes.
How do you guard against the perception of legislating from the bench or being aligned with the person that nominated you? Or do you just apply the law fairly, independently, impartially?
Well, that is a question that I think every single one of us have to ask at the time on the case. Because in my view, if you are applying the law to the facts, and of course there are always going to be competing cases, competing facts that the parties bring to you, it's their responsibility to do that. But as long as you can base your opinion on the precedent or prior statutory interpretation, or if you are in a district that goes back into the legislative meaning, I think that should at least go a long way with explanation in the opinion. I do think when you shy away from explaining fully and carefully all of the nuances and really, and I think you do have to be mindful of is this a case that I want to spend time really delving into the writing on? And sometimes that's the difference that it makes to the parties. I think that, there was a time when I did have a thought that I got frustrated, that all the parties do are flip to the back page and look at it is so ordered, right? And I have to constantly remind myself that there are real issues to be determined here, and I have to explain to that party why it is I ruled the way that I did. And I think as long as you do that, and it's grounded in the statute, prior precedent, I think you're doing what you're supposed to do as a judge. And as I mentioned, I've become probably accustomed to sort of flagging in a footnote or something of that nature. There are competing statutes, or there are competing courts that have ruled a different way, and here's my reasoning. I think if you lay all of that out, the tendency is to be really thought of as a person who is not going to legislate from the bench. It's a really hard thing for me to explain, but I think you know it when you see it, right? And for me, I've had many of these moments. It's the gut check moment when you're having a hard time signing the opinion because, you know what, I feel badly for the result. But then you have to walk away and say, but that is what the law says. And let the legislature address that issue. If you don't have many of those gut check moments, then I'd probably say you probably need to just kind of look back, take a step back and look at what your opinion says and why you ruled that way. What is the supportive law? What is the supportive precedent? What are the facts that lead you to that decision? But for me, it is those gut check moments where you just, gosh, I wish it was something else. That's how I deal with it. Thank you for your patience. Thank you for your interest and your attention. I really am honored to be here back at the college, and I, again, appreciate the president's commitment to all of you, and thank you. Thank you so much.
Judge, thank you for the thoughtful remarks, for challenging us to reflect on our judicial oath and do whatever we can to ensure that the public understands what we do, and that hopefully your words will ring true in terms of how we can improve the public confidence in our system. So thank you. As a token of our appreciation, we have a golden gavel, not golden, crystal gavel, as a sign of our appreciation for you taking your time today. So thank you so much.
Look at that. Oh my gosh, that is beautiful.
And we will ship it so that you don't have to go through the TSA.
Thank you. Thank you so much.
Thank you again. Thank you all for joining us today. And for the Judicial Academy, good luck. And for the rest, we'll see you next week. Thank you so much.